this is State of Ohio versus Tancak. And both sides will have 15 minutes to present their arguments. And obviously the appellant may reserve time. And if you'd like to reserve up to 5 minutes, you can, Ms. Bremke.
I would reserve 5 minutes of my time.
Okay, I just want to give you just the standard warnings. You know, we are being live cast. And so we don't mention victims' names and we don't mention children's names. Okay?
Okay.
All right, you may proceed.
Thank you, Your Honors. Giovanna Bremke on behalf of Mr. Justin Tancak. This case involves a plea and sentence, so there aren't many facts of the case. There were two assignments of error. Mr. Tancak was indicted in November of 2016 on several counts, 8 different counts, including one count of failure to comply. In the first assignment of error, we've raised that the trial court failed to comply with Criminal Rule 11 in failing to advise Mr. Tancak of that the sentence for failure to comply would have to run consecutive to any other sentence. The state has conceded as to the failure to comply that the Rule 11, that the trial court did not comply with Rule 11. For that reason, and feel free to ask me questions on that, but for that reason, I would like to focus on my second assignment of error, which is that the entire plea must be vacated because of that error. The court I rely on State versus Cleveland, and I know I'm anticipating that you're going to ask me about any sort of plea agreements. So I'd like to speak to that. So I would agree that there was no agreement for a particular number of years. However, I would like to bring it to the court's attention that because of the trial court's failure to instruct Mr. Tancak on the consecutive sentences, that puts him in a position where several things. One is if he goes back to the trial court, then he is now, he's already pled to the other counts, and it would be impossible for, say he wants to go to trial on that one failure to comply count, assuming that that'll get reversed because of the state's concession and my raising of that issue. Then all of those facts, which he's already pled to, would have to come in, and it would be impossible to separate those facts. Now, a lot of those facts, again, are not in the record because by virtue of this being a plea, there wasn't a lot of facts in the record. But, ultimately what happened in this case was the failure, there was a chase, and that resulted at the end in the death of a young lady who was a passenger. So those facts, again, would have to come forward in order for the failure to comply. They're so intertwined in order for Mr. Tancak to go forward. So when he pled and he didn't consider that consecutive sentence because the trial court didn't instruct him. He also, didn't consider the entire, that would affect the entire plea because he wouldn't have considered that later on if he, had to go forward on the failure to comply, that all of these other facts would go forward. So that's one issue that I wanted to bring to the court's attention about the failure to comply and why the entire plea should be vacated. I would reserve the rest of my time and for rebuttal.
Okay, thank you. Thank you. For the state, 15 minutes.
Thank you, Your Honors. Lindsay Poprocki of the Lorain County Prosecutor's Office on behalf of the appellee, State of Ohio. As the appellant has indicated, the state has conceded that the trial court erred by failing to advise the appellant that by pleading guilty to count 3 of the indictment, which was failure to comply, it would be mandatory for his sentence to be served consecutively to any other prison term imposed, and therefore his guilty plea to failure to comply was not entered into knowingly, intelligently, and voluntarily. The state's concession is limited in 2 respects, however. First, the state's concession is limited to Tancak's first assignment of error, and the state's concession is further limited to the fact that Tancak's plea to the charge of failure to comply should be vacated. Thus, as Tancak actually indicated, the real issue for this court's consideration is under Tancak's second assignment of error and turns on whether his entire plea must be vacated as a result of the trial court's error. Tancak asked this court to vacate his entire plea. In doing so, he proceeded in his merit brief under the mistaken premise that the entire plea is invalid because it was obtained pursuant to a global plea agreement with the state. This is inaccurate, as he now indicates, and rather, Tancak pled to a multi-count indictment with no agreements toward sentencing. I would note that he further in his brief cited to multiple cases regarding a trial court's participation in the plea bargaining process, and in a specific case which cautioned that where a trial court participated in a plea bargaining process or promised a certain sentence, that the promise became an inducement to plea, and unless that sentence was given, the plea was not voluntary. But those cases are really irrelevant to this appeal, as he cited as Tancak developed no basis for a citation to those cases and didn't develop any citations to the record for the citation to those cases either. So I would ask that the court not consider those cases. Again, Tancak's plea was not the subject of a larger plea agreement, and we would ask that his citation to the Cleveland case also not be given any consideration. The state cited to a first district case out of Hamilton County in its brief, State v. Maggard, that stands for the proposition that each count in indictment is independent of one another, such that an error by the trial court has no essential influence upon the other and does not automatically require an entire plea to be vacated. The facts in Maggard we would submit are important to this court's consideration of Tancak's appeal. There, the defendant, like Tancak, argued that his pleas were not entered into voluntarily. There, the defendant had pled to 6 counts of rape, 4 counts of abduction, and 4 counts of kidnapping. Upon review, the first district held that the trial court did not substantially comply with Crim Rule 11 in accepting the defendant's pleas to the rape charges, because although statutorily required to impose a prison term for the rape offense, the trial court and even the defendant's counsel indicated to the defendant that the prison term on rape was not mandatory. Therefore, the record lacked evidence that the defendant knew that his sentence, that he would not be eligible for community control sanctions on the rape charge. So, as is the case here, because no plea agreement existed between the defendant and the state, and the defendant was properly informed of the possible punishment he could receive by pleading no contest to the kidnapping and abduction charges, the first district held that those convictions did not have to be vacated, even though the rape charges had to be vacated. Here, the state is asking the court to follow the reasoning in Maggard. We concede that the trial court's error in accepting the trial court's error in accepting the guilty plea for failure to comply does not have to automatically invalidate Tancak's plea to the remaining counts of the indictment. This is especially true where Tancak's guilty pleas to the remaining counts were made voluntarily with knowledge of the maximum penalties involved.
Counsel,
Yes.
in Maggard, did the trial court specify the maximum number of years that the defendant might get at sentencing?
I honestly can't recall that. I just know that the first district held that because he was advised of the maximum penalties involved for each count, but he was not advised that mandatory time would be involved with the rape offense, that they upheld the convictions on the other 2 counts.
Well, it's my understanding, and correct me if I'm wrong, in this case, that the trial court actually indicated that the maximum number of years that the defendant could serve was 8 years when he was ultimately sentenced to 9 years. Is that correct?
He was advised of the maximum penalties involved with each offense in this case. And then the failure to comply was run consecutively with the aggravated vehicular homicide count.
I also believe he was advised that the number of years that he could be sentenced to would be 8 years. Does that matter here?
I think in the advisement, he said count 1 carries 2 to 8 years in prison. And then he went on to advise as to what each count carried. So he advised us the counts, each counts individually.
Okay, thank you.
If that answers your question.
Thank you.
Okay.
Counsel, I had a question as well. I understand the argument. I understand, how the first district ruled. I'm just trying to figure out how do you piecemeal this out in regard to when you're making a decision as to whether you're going to plead to something, if you don't know exactly the full consequences of it. Maybe you make the decision, gee, I might as well just go to trial if I'm going to have consecutive sentences or a mandatory. Obviously we're not compelled to follow the first district. I'm just trying to figure out, because that's usually not the way it works. If the whole point of making sure it's knowing, intelligent, and voluntary is that you have the correct information that's given to you.
I understand your question and whether the error. So basically the other side of the coin is whether the failure to advise on one point affects the decision to enter into the plea in its totality. And we would just ask that the court find that because he was advised as the maximum penalties on the remaining counts, that the Tancak has not made an argument in his merit brief as to how the other counts were affected. That argument is being made for the first time in the oral argument, I would submit. He had an opportunity to raise the arguments he is making today in a reply brief. And I would just ask that the court follow the arguments made in Maggard, and that each count of an indictment is in and of itself a separate count that does not necessarily have to be vacated based on an error to another count.
Thank you.
Thank you. And
I'm sorry, do you have another question, Judge Sutton?
No, thank you.
Oh, I'm sorry. I thought somebody said something. Okay, then counsel for the appellant, you have 5 minutes remaining.
Yes, Your Honors. If I could address some of those arguments, and I'm glad, I believe it was Judge Carr that brought this under the state's attention. And although obviously our record here is limited, but I think what you all can use as your experience as judges and trial court judges in the past, to understand that when a defendant enters a plea and they're anticipating their consequences, and this is what my client is indicating to me, that it was something that was not, that the consecutive sentence was not considered, and that would have affected his entry of the plea. It certainly would have, and that's something that I think each defendant would consider, not just my client, but I think that that's something that each defendant would consider when entering a plea, within anticipation what the consequences are. And I would agree.
Let me ask you a question about that. If I'm correct, your client pled to the indictment for pre-sentence investigation, and the state took no position on sentencing. Does that pretty much sum it up here for this case?
I don't know that they took no position. They argued at the sentencing hearing, but I would agree with you that there wasn't a recommended sentence to the judge.
Well, couldn't the trial court have imposed consecutive sentences no matter what, assuming that the statutory factors were addressed and met? Now, I know that's different than the mandatory consecutive nature of the willful flee here, but consecutive sentences was never out of the question as a possibility. Isn't that a fair statement?
Well, I think it's different that in this case, it was statutorily mandatory that it's consecutive sentences. And that's what makes it different, because no matter, even if, the court could have given him the max on each count and had to run them consecutively. So it's because there's really, it's not a matter of the court's discretion so much as the court really doesn't have the discretion under the statute on whether to run it, consecutive or not, that they have to. And I think that's what makes the difference here, is that undoubtedly would add to the entire sentence, because it has to be under the statute consecutive. So that failure to advise on that one count has an effect on the entire sentence. And like I said, if this goes back for a trial, there's no option but to, what I would say, open the floodgates of all of this other information that's already been pled to. And that's not something that he anticipated when he had pled, that one count would have to run consecutive, and there would be a possibility that he could come back and have all of that other information held against him in the failure to comply trial, anticipating in the future that there could be one. And that's, certainly, I think that demonstrates prejudicial effect on this plea, that is something that one wasn't considered when he pled, because he wasn't advised. And also that, again, that if this comes back, this is opening the floodgates to all of that other information, almost like a double jeopardy, because you have to try him for things that he already pled to. And that wasn't something that was considered at the plea. So again, that goes to whether the plea was knowingly, intelligently, and voluntarily made. Not considering all of that, and particularly this consecutive sentence that was mandatory under the statute, that's enough to justify the fact that this whole entire plea needs vacated as to all counts, all 8 counts.
And counsel, that's your 5 minutes. So excellent. All right. We will thank you both for your presentations to the court, the arguments that were made. We will take the matter under advisement, and we'll issue a written opinion, as well as release the opinion online. So